This is episode number 157.
You have to listen today. We're featuring a name you don't know, Sam P. Israel. He is a copyright attorney with a specialty in copyrights for artists, and you need to hear every word. This could save you.
This is the PleinAir Podcast with Eric Rhoads, publisher and founder of PleinAir Magazine. In the PleinAir Podcast, we cover the world of outdoor painting. Called PleinAir, the French coined the term, which means open air or outdoors. The French pronounce it plein air. Others say plain air. No matter how you say it, there is a huge movement of artists around the world who are going outdoors to paint. And this show is about that movement. Now, here's your host, author, publisher, and painter, Eric Rhoads.
Thank you, Jim Kipping, and welcome to the PleinAir Podcast. My name is Eric, and it's hard to believe we're coming up on the month's end. Time sure flies. Next thing you know, it's going to be May, and we're going to be at the PleinAir convention, and that time will happen in a flash. So you got to make sure you get those seats. Come to the convention. We've got an incredible lineup. We've got a beautiful Colorado painting. It's going to be incredible, but really there's not much left in terms of seats. So get them. I'm not playing games here. I'm not creating false scarcity. I mean, we have had the biggest, most successful convention sales we've ever had, and we're just about out. So go to pleinairconvention.com for those seats. I've got my big 10-year anniversary event coming up, the Publishers Invitational in the Adirondacks. 10th year, it's kind of fun. We're going to celebrate. People are coming back who've come over the years, and of course, a lot of new people coming. It's the Adirondack Mountains in upstate New York. It's absolutely beautiful. A lot of people come from all parts of the country. I mean, we've had people from California, even had people from Russia, even though it's back east in the East Coast, and it's kind of upstate New York near the border to Canada. It's just beautiful, mountainous and waterfalls, and we just go out and have a good time and paint every day, and food's good, and the company's fun. We sit up at night, and we paint portraits, and we paint all day outdoors in these beautiful locations. We each end up with, 14, 15, 18 paintings at the end of the week, and some people more. Terrell Gable, who comes every year, she probably ends up with 30. Anyway, she's an animal. She gets out at 5 o'clock in the morning. But the rest of us kind of sleep in, have fun, get up, have breakfast, and you don't have to do anything. You show up, the food's there for you, you just paint all day. It's a lot of fun. It's the Publishers Invitational in the Adirondacks. You can learn more at publishersinvitational.com. Coming up after the interview, I'm going to be answering art marketing questions in the Marketing Minute. Let's get right to our interview. You're going to love hearing this. This is about copyrights with the attorney. His name is Sam P. Israel. Sam Israel, welcome to the PleinAir Podcast.
Thanks for having me.
We're glad to have you. I think this is going to be a unique podcast. You know, most of the time we're interviewing artists, sometimes art historians, but the issue of copyrights and protecting one's rights as an artist comes up so much. I thought it'd be really unique to do something with this. And my understanding is that you're the expert. Is that correct?
I don't know that I would call myself the expert, but I am among people who know about the field and certainly know quite a bit about trademark and copyright law.
Terrific.
As it relates to the arts.
Excellent. Well, why don't we jump into it? Can you, just for the sake of our listeners, tell them what you do and give them a little bit of background about how you got involved in copyright work and trademarks for artists?
Sure. I've been practicing for about 35 years. I have a small firm, 5 lawyers, and I myself am an artist, visual artist, and I have always gravitated toward the arts. I studied art in college, and I went to the Art Students League, etc. And I naturally found it very I'm sorry, let me turn that up. Found it very suitable to learn more about copyright and trademark as it relates to what I do and what others that I am friends with do, and have provided assistance to artists over the years who have been in all kinds of quandaries regarding the ownership rights that they have with their artwork.
Excellent. So before we go into that, who did you study with at Art Students League, and what kind of work do you do?
I studied with Anthony Palumbo, and I do representational painting, and I do a lot of collage work, and I think that's the majority of the work that I do.
Well, I think, as artists are sometimes distrusting of people who don't understand what they do, so I think that's a real advantage that you have, is that you know what they go through, you know their world, because you're living in that world as well.
Yes.
So what are the biggest issues that you think we need to discuss that artists face?
Well, there's a number of issues that I'm seeing most recently that relate to the Visual Rights Act of 1990 and the Copyright Act, in terms of how artists can control their destiny, how artists can control how their work is used and when it shouldn't be used. And they both those areas arise under those two acts. And one of the things we see, for instance, is artists making sure that their work is treated appropriately, that they get proper accreditation, and that other people don't commercially exploit their work. And within that range of entitlements, we see all kinds of disputes. I should mention that mostly what I do is litigation. I occasionally advise artists on things like, when they have dealer agreements and what should go into the agreements and things like that. But primarily they bring me on when there's a suit or when there's a dispute as to rights.
Well, I think that's even better, because you're the guy that has to defend it in court, and so you can tell them what works and what doesn't work. And we'll talk about dealer agreements too. But I was walking through a shopping mall one time, and there was a gallery, and I was with a friend of mine, and we looked through the window, and I said, "Hey, there's some of your paintings in there." He says, "No, I'm not in that gallery." And I said, "Yeah, you are." And we walked in, and so he kind of played dumb, and he said, "Tell me about that artist." And the dealer said, "Oh, he's telling him all about him and telling his story and so on." And he said, "Where did you get those paintings?" And he says, "Well, I have a source, right?" And he says, "Well, I am the artist. Those are my paintings, and you're not authorized to use them." And the dealer actually, I was with him, and he actually was shocked. He says, "Well, come with me. I got him out of this catalog." He buys these paintings from China. There was a big, thick catalog that must have had 5,000 paintings in it. And he said, "I just go in here and I pick them, and they actually paint them and send them to me." And so he said, "Well, these are things that I've put online that they've copied." So how do you prevent that kind of a thing, or can you?
You can, to the extent that you could go after the person who's selling it as a contributory infringer. Of course, going after the people who are making the stuff in China is a thankless job, but anyone who's selling something that's copyrighted in the U.S. Is going to be susceptible to liability for selling something that is infringing. So you could go after the dealer for saying, "Hey, you don't have the rights to do this," and if they don't accept that and cease and desist what they're doing and pay you what you're entitled to, pay you something reasonable for what you've done and what they've sold, then you could file suit against them. And with China, it's a little bit more difficult. There's no extraterritorial reach of the Copyright Act, and there's really practically nothing you can do to stop what they're doing in China, unfortunately, which is an ongoing problem and is to a lot of people's disappointment.
Well, I think at least you have some action, and if you could find out dealers that were using things out of these catalogs, that you could start going after all of them, really. And the whole idea would be to shut down the people who are selling these things. And chances are it's a U.S. distributor.
You could do that. And if there is a U.S. distributor, you could go after the U.S. distributor. Again, all for contributory infringement. You could get an injunction stopping them from doing what they're doing. There's a number of things you can do as long as there's the U.S. contact.
Now, in terms of the kinds of infringements that you seem to see a lot of, maybe it's this Chinese kind of a thing, but what other kinds of things do you see that are happening a lot to artists?
Well, I see, most recently we've been getting involved in some cases with graffiti artists whose work has been appropriated for advertisements and for all kinds of mixed media phenomenon without giving credit to the graffiti artists who have a right under VARA, the Visual Arts Right Act, to accreditation and to be able to claim that it's their work. And for that matter, under the Copyright Act also. And it seems to be that people think that if it's graffiti, it's up for grabs because it's in a public space. And in point of fact, it's not. And that seems to be like the most recent phenomenon, the area where the law has kind of developed the most recently. But you see it in all kinds of situations, copyright infringement from somebody just, cloning an image from a painting, reproducing it, and not giving any royalty or not giving any compensation to the creator of the work who owns the copyright. So it's a pretty pervasive phenomenon.
Yeah, actually, we surprisingly see it quite a bit in terms of artists will see something they like online and they'll copy it and they'll claim it's their own. Or sometimes they'll enter it into an art competition. We also see a lot of artists who are lifting antique images, things that may be out of copyright, may not be, and copying those and claiming them as their own.
Right.
So in terms of what an artist can do or should do up front, what are the basic things that, what should I put a copyright symbol? Should I put all rights reserved? What should I put on the front and the back of my paintings as a starting point?
Well, the first thing you should do is you should register with the Copyright Office your artwork. And the reason you do that, by making a reproduction of it and filing it with the Copyright Office. And the reason you do that is because if somebody infringes your work, if you do that afterward, it's prerequisite to go after them to file a copyright infringement suit that the work be registered. Now, if you register the work before it gets infringed, you'd be entitled to recover something called statutory damages, which could conceivably be much greater than actual damages being what was achieved by the sale of the infringing work. So it always makes sense to register your work with the Copyright Office. It's not a difficult process. It's very simple, and it's not expensive. And in some instances, if there's a lot of work, you can do it in mass by bundling the work together, categorizing it as a certain type of work, and filing it as a group. But my advice is to always register with the Copyright Office any of your work.
So I complete a painting. I'm going to take a photograph of that painting and then go online to the Copyright Office and fill out a form, give them $10 or whatever they require, and then that accomplishes it?
It does.
Okay.
And you should do that all artists should do that as a matter of course, especially if they have plans to commercially exploit it. If they plan on licensing it or doing anything with it other than just selling the painting, it makes sense to protect it that way, because the more it gets out there, the more likely it is that somebody's going to illicitly exploit it. So more power to you if you register the copyright in advance.
Well, and I think, a lot of times people will paint things and not necessarily have a commercial intent. And then later down the road, they start getting a little success. And next thing you know, they've got a lot of work out there in the marketplace. If I sell a painting to somebody, and let's say that person who bought my painting decides they want to do reproductions of my painting, and sell posters of it or something, they don't have that right, do
Right.
they?
No, of course not.
So
The only way they would have that right is if you gave it to them, if you had an agreement with them which specifically conveyed that right, or if it was a work for hire. In other words, if somebody paid you to do the painting and it was clear per a work for hire agreement that you were doing this for them and you surrendered all of your rights and entitlements vis-a-vis the painting. Short of that, they can't do it.
So if I've done somebody commissions me to do a painting, a landscape painting, and I do it for them, they then, because they paid me for that, they automatically have that right, or do I still have to transfer that right?
You still have to have an agreement.
Okay.
You have to have an agreement that makes clear that it's a work for hire.
Okay. So and this is a pretty common issue, this idea of people commissioning paintings. And so is there something you could do to prevent that just automatically? Would that be not having an agreement and just putting a statement on the back of the painting, or do you have to have an agreement in every case?
I'm in favor of clarity. So what I would do is I would make clear with the person I'm doing this for that, by the way, this is not a work for hire. I'm doing this painting for you. You'll own the physical painting. You'll be able to display the painting, but any rights to reproduce the painting are still with me. And to make that clear, and that could be the subject of an agreement. Granted, you need to have a work for hire agreement to assume the rights that I'm talking about, but I think it's best to be ultra clear up front and make it plain that rights of reproduction still remain with the creator, with the artist.
Now, I see a lot of artists who are doing a lot of different things. Some artists will put their signature on the front. You can't read the signature. As a matter of fact, I have a friend who they discovered a painting recently and they can't read the signature and they don't know who painted it. There's nothing on the back. I have another friend who always puts a Circle C and his signature. Is there a proper way that we should be signing our paintings, and is there something specific that we should be putting on the back? For instance, on mine, I put copyright the year, all rights reserved, or I think the order I put it is copyright 2020, be Eric Rhoads, all rights reserved. That's how I do it. I don't know if I'm doing it right.
Well, you're doing bells and suspenders. What you're doing is right. It's the maximum way to protect yourself. Most people don't do that or don't do anywhere near that, but it can't hurt you to do that. You're making very plain that you retain the copyright and who it is that retains the copyright, so I would encourage you to continue to do that.
Is there a better way?
The best way to do it would be when you are at the point of sale, to have an agreement with the person you're selling it to, or even displaying it with, that it's clear in the agreement that you're retaining the copyright and that person you're selling or showing it with doesn't have any rights towards reproducing the work. So if it's a dealer, you have in your dealership agreement that you're not conveying any rights to reproduce the work and you're retaining the copyright.
All right. Now, you can you could in the agreement say, I suppose, except for use of the images on the website, but they need to be removed.
That's right.
At a certain point. Okay. And let's talk about dealer agreements. I know lots of artists who have gallery relationships. They have no dealer agreements whatsoever, and I've heard horror stories of artists who a gallery went bankrupt. Their work, they never recovered their work because the bankruptcy court just assumed that the gallery owned it. What should be in a dealer agreement, an artist dealer agreement?
Well, for one thing, what you're saying means that somebody didn't do what they should have done, because the fact of the matter is there's always an agreement, even if it's not written. There's an understanding between the parties as to who owns the work and when it comes back to the owner. So it may not have even been recorded, but it's hard to imagine that somebody would give their work to somebody and say, hey, it's yours, do what you want with it. There's usually some kind of understanding that you're going to display this, but I'm still going to own it. If you sell it, I'll get a percentage of the sale, as will you, and that's the way this thing works. But to the extent that that isn't said for some reason, it always makes sense to have a writing. And the writing should make clear what the percentage that will be achieved by the seller, the percentage that's retained, and that in the event that there is no sale, that ownership still vests with the creator. Those points should be made very clear. I should add, though, that dealers who work on a consignment basis have a fiduciary duty to the artist, which means to say that they are obliged to get the best price, to not do anything that would compromise the rights that the artist has, and to return the painting in the event that there is no sale. Now, all the time, that doesn't happen lots of the time, which is why we see so much litigation. The majority of the litigation that you see in the art world is litigation over consignment agreements that have run afoul of what the gallerist's obligations are. So the more you have a crystal clear agreement saying that you retain the ownership and you retain the rights, and what the percentages are, and that the rights and that the painting reverts back to the owner, more power to you.
And should there be some kind of a statement in there about, in the event of, the company going under or closing down or going into bankruptcy, notification needs to occur, and paintings need to be returned or at their expense? How do you deal with those?
What you need to do is just make sure that it's clear that you own the painting, so that if there is a bankruptcy filing, it's not property of the estate. That's the big concern. So if you have an agreement that acknowledges that ownership of the painting still vests with the creator of the painting, then you won't have a problem if there's a bankruptcy, because it won't be property of the estate, and you'll be entitled to get your painting back. That's very important.
So, sometimes I hear stories, horror stories, of artists violating agreements with galleries, and sometimes the agreements are written, sometimes they're unwritten. But I remember going into a gallery in, I think it was Tucson, and the man was taking paintings off the wall, and I said, "What are you doing here?" He says, "Well, I had this artist who was in here, and I fired her." And I said, "Why?" And he said, "Well, a guy came in, tried to negotiate a price on the painting. He didn't like it, so he left. He contacted the artist direct, bought it for less money, and then foolishly called me and said, hey, screw you. I was able to buy it direct from the artist." So he fired the artist. And one of the issues that we constantly hear about are, at what point is, does that agreement work the opposite way? Is this an agreement of, you promise not to sell direct to our customers for the period of time we represent you, kind of a thing? Is that a pretty standard approach?
It is a standard approach, and the artist shouldn't have done what the artist did if it's an exclusive agreement. sometimes consignment agreements aren't exclusive. So you could have a deal where I'm going to show my artwork through you, and if you sell it, then you get this percentage and I get, this percentage. On the other hand, if you don't sell it, you get nothing, and it's understood that it's not exclusive. It all depends upon what the agreement is. The case you're describing, it sounds like it was an exclusive agreement, and the artist just went around the dealer and screwed the dealer, in which case he was bad, and I can understand the dealer being aggrieved by it.
I had a situation one time. I believe that if a dealer generates a lead, a customer, that I should honor that dealer with some benefit for bringing that customer to me. So I was in a show at a gallery in Annapolis, and the show sold a couple of paintings, and then I had posted all my paintings on Instagram, and then 3 months after the show, this person contacted me and said, "Hey, I bought one of your paintings at the show. I'd like to buy this painting that you have on Instagram." And I ended up parlaying that into selling 2 or 3 more. I turned around and contacted the gallery and said, I wouldn't have this customer if it weren't for you, so I'm sending you a commission. And they were really happy about that. But is there a kind of a standard on that, or again that just boils down to what the agreement is with the customer? So if a lead is generated, or a customer comes to you direct, or if a customer comes to you, after you've left the gallery, I guess that all boils down to what you put in writing, what the agreement is.
That's what it boils down to. And sometimes it's not uncommon for dealers to acquire rights to an artist's entire catalog. They'll just be an exclusive dealer, and anything the artist sells, they'll get a percentage of, regardless of how they found out about the art, whether it was a listing online or otherwise. But if it's like many cases where it's just, I have these rights vis-a-vis the work that I'm showing, then what you would have done would have been on the very generous side. Let's put it that way, because I wouldn't have expected that you would have given a percentage based upon sales online if it wasn't directly from the show. Again, it's a contractual matter. It depends upon what the understanding is, and it depends upon whether there's exclusive rights vis-a-vis the artist.
I know you're not an estate guy, and so this question may or may not be something you can touch on, but I remember hearing a story of an artist who had accumulated a lot of work, and that work, the IRS came in basically upon his death, put a valuation on that work based on the previous sales, and then his family got socked with a big tax bill because they now owned all this artwork. Any thoughts on that?
It happens quite a bit. I have a case right now with artwork that's worth tens of millions of dollars, and we're struggling with how to deal with it, to cut a deal with the IRS on the artwork, which was left by a will, and it's very tricky stuff. And I'm not, as you pointed out, I'm not an expert in this area, but I am aware of it being a serious problem.
Yeah,
can be a serious problem.
And I think IRS law allows you to. There's a certain amount of gifting you can do every year. So I think some artists will gift some of these paintings to their children or something every year, just to kind of get them out of the studio. I mean, the nightmare is we have thousands or hundreds of paintings in our studios that some of them we don't expect to ever see the light of day because they were studies or they were things that we would never even consider selling, and yet someone who does not necessarily know the industry comes in and assumes because you sold all these other paintings for $4,000 that these are all worth $4,000. Right.
The best thing to do is to put them in a trust, and I can't give any explanation of how it works, but I can tell you that just as a general proposition, to put the artwork in a trust may be able to enable you to get over the inheritance tax. If you put it in a trust under somebody's name where they're kind of a putative or an equitable owner of the artwork, you might be able to avoid the estate tax. But you need to but who's ever listening needs to talk to an estate person to get more clarity on that.
You know, one of the things that we're all doing is we're posting things on social media all the time. You know, it's kind of, hey, look at me. Here's my progress. Here's my finished painting. Most of the things I see don't have any watermarks, don't have any copyright statements. You know, you hear stories of people seeing things and copying from Instagram. Is there anything that you recommend? And also, you know, you see these things that people post on Facebook that say, you know, you hear these rumors that Facebook has rights to all the images that are posted, and you know, people go through certain things to try and prevent that. Any advice in this area?
You have to be very careful. For instance, with Flickr, which is another area where a lot of artists post stuff, me included, you surrender certain rights when you put stuff up on Flickr. For instance, they have the right to reproduce your artwork and sell posters and things without giving you anything in exchange. And you have to read the fine print. And again, it always makes sense to copyright the work beforehand. But it depends upon what the individual service provider has in their contract and whether they can kind of pillage your intellectual property without paying you for it.
I had one happen to me on Flickr. So I had put a picture of me and a buddy up on Flickr from a cocktail party. And one day I got a call from somebody in my family, and they said, hey, you're on the front page of the paper here. And I said, what? And they said, yeah, here's a link to the story. And there was a story about sugar daddies. And because it was a picture of me in my, you know, mid-50s and a buddy of mine in his mid-50s, they pulled that off of Flickr. So I called the newspaper and I said, what's the story here? You're using my image. They said, yeah, we got it off of Flickr. It's copyright free. And they were generous enough to pull it from the online story, but they said, we don't really have to.
It's true.
Yeah.
It's true. I mean, I put stuff on Flickr too, just because it's convenient and I want to get my work out there. But it's not the most prudent thing to do, to the extent that I plan on making money off any of the artwork, because you do give them a license to resell it.
So let's talk about licensing, because you mentioned that earlier. For the artists who are listening who might not know what this is, you can take images of your artwork and license those to other people to sell those images. So a friend of mine, Charles White, for instance, he's on coffee cups and mouse pads and calendars and jigsaw puzzles. And, you know, he uses a publishing company out of Minneapolis who publishes his work. And, you know, he's making some money on it, and, you know, he has an agreement, and it's all very beautiful. But, you know, once in a while, I think some things end up published probably by unscrupulous firms without any permissions. What should be in publishing agreements? Is it pretty much the same things?
Yeah, in publishing agreements, you have to make clear the limits to which things can be published, and you have to make sure what your entitlements are for reproduction of your work, and how there can't be sub-licensing agreements entered which give your rights away, which sounds like maybe the case in the circumstances you're talking about. And if you do that and you do it carefully, it shouldn't happen. If it does happen, then you've got a claim for copyright infringement.
So what about forgeries?
Forgeries is What about them?
Well, I guess the forgeries is the issue that we talked about earlier, like the Chinese forgeries and so on. But I didn't know if there was anything else that needs to be added to that discussion about, anything to prevent forgeries other than what we talked about.
You have additional claims in the case of forgery for arising from trade dress and false designation of origin under the Lanham Act. So you have the protection that you've got ordinarily under the Copyright Act and under VARA, but you also have protection under the Lanham Act when somebody's attributing work to somebody else who didn't create the work, or if it's a forgery and it's attributed to the right person, but it isn't their work and just looks kind of like their work. Again, you have claims under the Lanham Act, the Copyright Act, and under VARA.
Now, one thing I see on occasion, and sometimes it's innocent and sometimes it's not, is, I was in an art class and the art instructor said, hey, go find a picture online of a beautiful place and I'll teach you how to paint it. The problem with that is, of course, I suppose if you're using it for learning and you never show it or never publish it, that's one thing. But talk about the idea of taking images off of stock photo sites or just generally offline and using them to create paintings. What are the issues that an artist faces there?
Well, you've got copyright issues if you take it off stock photo sites, unless you meet their requirements. Like stock photo sites have a minimal amount that you pay to use their stock photos. And as long as you pay that amount, then you should be fine. If it's not a stock photo and it's somebody's property, you run into issues of rights of publicity, and you run into issues of potential copyright infringement, because there's copyright in the designs of places, in the architecture of places, and reproducing buildings, for instance, is not free from peril. But they're two different issues: the stock photos and copying something that structure, for instance. They involve different. They both were down to copyright, but one of them, there's a safe way to do it, namely with stock photos, because they just ask for a nominal fee. And if you're copying somebody's building, then you should get permission to do that.
There's a tree in Carmel. You're probably familiar with this. There's a famous tree that kind of is the trademark of Carmel, and it, technically speaking, it's illegal to photograph that tree and to publish it. And painters who have painted it and then sold have been sued by the city of Carmel, who owns the rights to it. Even sometimes there's a landscape that you could be copying that you can't use.
It doesn't surprise me. It doesn't surprise me. I could see that too.
So
I know we get a lot of cases. We get a lot of cases, though, where it's not landscape, but where it's architecture, and where somebody copied a building, for instance, and it was deemed to be copyright infringement, or at least it was claimed to be copyright infringement, and that's not uncommon.
So if I'm standing on the street, I find a really beautiful little house, and I'm standing out on the street, not on their property, and I decide I'm going to paint a picture of that house. Could that homeowner, if they had the house copyrighted, come after me, or could they come after me anyway?
The person who created the house could come after you, and it's unclear whether that person will have conveyed the copyright to the house to the owner of the house. But ultimately, the person who created the house could conceivably come after you for copyright infringement.
Now, a case like that's probably.
But if you're not going to sell it, and you're not going to commercially exploit it, the chances of somebody doing that are pretty slim. I'm giving you an extreme example. Let's say you painted somebody's house, and you sold 1 million copies of it, and it became kind of like a Saul Steinberg thing, where it was on the cover of New York magazine and was reproduced 1,000 times, then I could see there would be a problem. But it's unlikely that if you just do your own painting of a house and sell it to somebody else, that somebody's going to come after you for copyright infringement.
Probably a general rule is just always, if you can, ask permission, right?
That's right.
All right. Are there other issues that we should be bringing up or talking about that we haven't brought up yet?
Not that I'm aware of. I think we've done a pretty good job of covering the map in terms of current issues with artists and concerns.
All right. Well, this has been excellent. I think that it's an action-packed few minutes of really a lot of valuable data. If people were interested in contacting you, how would they find you?
My name is Sam P. Israel, and you can look me up online. It's easier to remember to put the P in the middle because there's other Sam Israel. So Sam P. Israel, and you'd find my phone number, and feel free to call me.
All right, and then you if somebody wants to do artist agreements with you, or gallery agreements or licensing agreements or anything else, you're the guy to go to.
Could do all that stuff, no problem.
Okay, well, this is very helpful, Sam, and it's a pleasure meeting you today, and thank you for being on the PleinAir Podcast.
Thank you for having me. It's been a pleasure.
Well, thanks again to Mr. Israel for this fascinating information on copyrights and contracts and everything else. Put that stuff to work, and of course, check him out or find somebody who can help you with that stuff. Shall we do some marketing ideas?
This is the Marketing Minute with Eric Rhoads, author of the #1 Amazon bestseller, Make More Money Selling Your Art, Proven Techniques to Turn Your Passion into Profit.
In the Marketing Minute, I try to answer your art marketing questions produced by you. Send them to me, Eric, at artmarketing.com. Here's a question from Jim in Bowling Green, Kentucky, which is a really pretty place. Jim says, I'd like to grow more as an artist, but I'm 22 years old and I'm unsure if I need to complete an actual degree. How much art education should I get? Well, Jim, I'll probably get in trouble here. Your parents and your school and colleges around the country are going to call me and yell at me, but quite frankly, I don't think to make a living as an artist, a degree really matters. What matters is that you're a good artist, or better yet, a great artist, and I would put your time and attention to becoming a great artist. If you need a school to help you do that, which most people do, then do it. And the degree is really about teaching. If you need to be a teacher in a public institution, a high school or a college, you probably need that degree. Probably want to get an MFA. So that is, the reason to get a degree, and you might want to do that so you can fall back on that, just in case. As a matter of fact, I was having a discussion with a friend last night, and he was talking about how he doesn't have his degree and he can't get teaching jobs in certain schools, and he'd like to. So maybe it would have been a good idea to do that. If I were going to get a degree and I was going to make my living as an artist, I'd get a degree in sales and marketing. Learn everything you can about advertising and marketing and sales and everything to do with that, and then, go to a great art school, an atelier like Grand Central Academy or Studio Incominati in Philadelphia or the Florence Academy in New York or Florence or other places. Become a great draftsperson, a great artist, a great painter, and you will flourish. I mean, the people that go to those schools end up, they're the best of the best, and they end up with great careers because they're so good. Nothing will overcome sales and marketing problems like being a really great artist. So think about that. Next question comes from Linda in Milwaukee, Wisconsin. You have to say Milwaukee, right? I think so. Linda says, is there such a thing as having a sales rep or an agent for my art to help me market and sell my paintings? I feel like I could use some help and would prefer to hire a professional. Where do I start? Well, the thing is, Linda, lots of us who are artists don't have that skill set. We don't want to learn that skill set. But, there are sacrifices. If you bring somebody else in, you're going to have to pay them. pay them one way or the other. There are reps or agents in all the arts. In Hollywood, you have to have an agent to succeed. And not so much in the art world, but there are many, many, many agents who do an awesome job. You're going to have to Google them or ask around, find out, talk to some galleries, find out which agents they like dealing with. And they, in theory, will help you build your career, build your brand, make awareness, get you into places to sell your work, maybe help get licensing deals. There's a lot of things. They're worth their weight in gold, and you're going to pay to have them do this for you. You know, so I don't know what they charge, but most agents are probably like 10%. And they're going to make you successful, and someday you're going to be making a lot of money, and you're going to go, oh, why am I paying this 10%? I don't need them anymore. Well, keep in mind that they made your career. They built you. And so you want to honor them by sticking with them. But anyway, that's part of your income, and that's part of what's going to make you successful if you're not the type of person. Quite frankly, I think if you're listening to things about marketing and you're studying marketing, yes, you can do all this stuff yourself. Somebody who's a pro, somebody who does it, somebody who does it every day, like myself, you know, I'm not an agent, and I've had lots of people ask me to be their agent, and I'm not going there, but I do marketing every day, and so my head is in marketing. If you get your head into marketing 20% of your time, you know, first off, agents aren't going to mess with somebody who's not up to the level that is going to make it easy for them to sell. They want artists who are going to be really good, artists that galleries are going to want, artists that are going to make it easy for them. So, you know, you might not be at that level yet, and if you're not and you want to make a living, you're going to have to do it yourself or get, you know, your spouse or partner or friend or somebody to do it for you. So you've got to master marketing. And quite frankly, I like to be in control of my own career. I never want to put anybody in charge of my career. Even if you have an agent, you need to understand what they're doing and understand the principles of marketing, because if you don't, you might get taken advantage of if there's some sleazy person out there who doesn't have any ethics. So think about that. Anyway, I hope this helps. This has been the Marketing Minute.
This has been the Marketing Minute with Eric Rhoads. You can learn more at artmarketing.com.
Don't forget to book your convention seat at the PleinAir Convention at PleinAirConvention.com. And also check out my Adirondack June Publishers Invitational event, publishersinvitational.com. If you've not seen my blog where I talk about life and art and philosophy and stuff, check it out. It's called Sunday Coffee. You can subscribe free at coffeewitheric.com. It's always fun doing this, spending time with you. Thank you for spending time with me. Let's do it next week, and I'll see you then. My name is Eric Rhoads. I'm the publisher and the founder of PleinAir Magazine and a bunch of other things like the PleinAir Convention and the PleinAir Salon. You get the idea. Lots of things. Anyway, remember, it's a big world out there. Go paint it. I will see you next week. Goodbye.
This has been the PleinAir Podcast with PleinAir Magazine's Eric Rhoads. You can help spread the word about plein air painting by sharing this podcast with your friends. And you can leave a review or subscribe on iTunes so it comes to you every week. And you can even reach Eric by email, eric@pleinairmagazine.com. Be sure to pick up our free ebook, 240 plein air painting tips by some of America's top painters. It's free at pleinairtips.com. Tune in next week for more great interviews. Thanks for listening.